Dear viewers, listeners, and readers. Assalamu alaikum. The employees of public and private sectors often fall in confusion how to know about the laws, rules, and regulations governing their respective service. In such condition they remain unaware of their duties and rights. Consequently, they fall prey to confusion and feel handicapped to ensure service delivery as required. Sometimes they lose their jobs. Departments/organizations also suffer. In order to sensitize the employees, this lecture series has been prepared. It is also aimed at creating awareness about various laws, rules, and regulations and aspects of public administration. The content of the lecture shall not be quoted in any kind of legal matter or reproduce in making legal claim, etc. I hope that the series will help the employees to know various laws/rules, understand different dynamics/aspects of their respective employment, and get them prepared for discharging their duties and responsibilities with peace of mind and up to the optimum level with efficiency and dedication in the public interest. The lecture series. Today lecture number 5 of the series is presented to honorable viewers, listeners, and readers. Topic of the lecture is intellectual property rights. Intellectual property rights are 3 different words/terms. Each has its separate meaning. A word intellectual is an adjective and relates to intellect. Intellectual means a person who thinks and conceives idea, concept, etc., or apply mind to create new thing, etc. Property means a kind of thing movable or immovable. According to World Intellectual Property Organization, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. Rights may be defined as entitlement of a person as per law of the land. These rights may be universal, international, or country-specific, etc. In view of the definitions of 3 terms mentioned above, a term intellectual property rights may be defined as protection of intellect property, movable or immovable, created and possessed by intellectual, person, or organization. According to OECD Glossary of Statistical Terms, intellectual property rights refers to the general term for the assignment of property rights through patents, copyrights, and trademarks. These property rights allow the holder to exercise a monopoly on the use of the item for a specified period. There are various types of intellectual property. Some are given below. 1. Copyright. 2. Patents. 3. Industrial designs. 4. Geographical indications. 5. Trademarks. 6. Trade secrets. In Pakistan, various laws have been passed for the protection of intellectual property rights. Intellectual property laws of Pakistan include the copyright laws, trademark laws, and patent laws. Moreover, Intellectual Property Organization of Pakistan has also been established in the country. The Copyright Ordinance was passed in 1962 in Pakistan. Section 3 of the Ordinance IBID provides for the definition of copyright. According to it, meaning of copyrights includes, in the case of a literary, dramatic, or musical work, to do and authorize the doing of any of the following acts, namely, 1. To reproduce the work in any material form, 2. To publish the work, 3. To perform the work in public, 4. To produce, reproduce, perform, or publish any translation of the work, 5. To use the mark in a cinematographic work or make a record in respect of the work, 6. To broadcast the work, or to communicate the broadcast of the work to the public by a loudspeaker or any other similar instrument, 7. To make any adaptation of the work, 8. To do in relation to translation or an adaptation of the work any of the acts specified in relation to the work in sub-clauses 1 to 6. B. In the case of an artistic work, to do or authorize the doing of any of the following acts, namely, 1. To reproduce the work in any material form, 2. To publish the work, 3. To use the work in a cinematographic work, 4. To show the work in television, 5. to make any adaptation of the work. 6. To do in relation to an adaptation of the work any of the acts specified in relation to the work in subclauses I, 2, 4. C. In the case of a cinematographic work, to do or authorize the doing of any of the following acts, namely, 1. To make copy of the work, 2. To cause the work in so far as it consists of visual images, to be seen in public and, in so far as it consists of sounds, to be heard in public, 3. To make any record embodying the recording in any part of the soundtrack associated with the work by utilizing such soundtrack, 4. To broadcast the work. D. In the case of a record, to do or authorize the doing of any of the following acts by utilizing the record, namely, 1. To make any other record embodying the same recording, 2. To use the recording in the soundtrack of a cinematographic work, 3. To cause the recording embodied in the record to be heard in the public, 4. To communicate the recording embodied in the record by broadcast. Chapter 14 of the said ordinance provides for offences and penalties to be imposed for publishing collections or compendiums of work which have been adapted, translated, or modified in any manner without the authority of the owner of the copyright, for unauthorized reproduction or distribution of counterfeit of copies of sound recording and cinematographic work, for exploitation and appropriation of recording or audio-visual work intended for private use, for making copies or reproduction in excess of those authorized by the copyright owner or his successors in title, for unauthorized rental of cinematographic works and computer programs, possession of plates for purpose of making infringing copies, for making false entries in the register, etc., or producing or tendering false evidence, for making false statements for the purpose of deceiving or influencing any authority or officer and false attribution of authorship, etc. Chapter 15 of the Ordinance provides for appeals to be submitted against the final decision or order of the relevant authority. Intellectual Property Organization of Pakistan has been established under Act passed in 2012. The preamble of the Act provides definition of intellectual property which includes copyrights, trademarks, patents, designs, layout designs of integrated circuits, trade secrets and other intellectual property laws, supported by other laws. The said Act provides, the protection of these and similar intellectual property rights of the citizens is essential to foster creative thinking, stimulate creativity, provide incentives for technological innovations, and attract investment. The establishment of Intellectual Property Organization of Pakistan is an institutional arrangement for taking up exclusively and comprehensively all subjects and matters relating to intellectual property rights in an integrated manner and for matters connected therewith or incidental thereto. The Act IBID provides various functions of the organization. Some functions of the organization under Section 13 of the Act are as under: 1. Manage or implement measures and standards on any matter related to or connected with intellectual property. 2. Accredit or certify any person as intellectual property agent. 3. Levy such charges or fees for services and facilities provided by the organization and its constituent offices with the approval of federal government. 4. Evolve and maintain a system to provide access to public documents and information relating to any intellectual property kept or maintained by the organization. 5. Plan for development and upgradation of the intellectual property infrastructure and capacity in Pakistan. 6. Promote education and research in the field of intellectual property. 7. Promote awareness about intellectual property issues in the public and private sector through print and electronic media, etc. 8. Initiate and monitor the enforcement and protection of intellectual property rights through designated law enforcement agencies of the government, federal or provincial, and collect related data and information. 9. Initiate and conduct inquiries, investigations and proceedings related to offences in the prescribed manner. 10. Initiate and conduct inquiries, investigations and proceedings related to offences in the prescribed manner. 11. Refer matters and complaints, related to offences under the laws specified in the Schedule, to the concerned law enforcement agencies and authorities as may be necessary for the purposes of this Act. 12. Engage in intellectual property rights advocacy. 13. Coordinate the implementation of foreign-aided technical assistance projects on intellectual property. The organization is mandated to create awareness and advocate for the intellectual property rights. Section 14 of the Act IBID provides, the organization shall promote intellectual property through advocacy which, among others, shall include a. Creating awareness and imparting training about intellectual property issues and taking such other actions as may be necessary for the protection of intellectual property rights. c. Holding open hearings on any matter affecting the state of intellectual property rights in Pakistan or affecting the state's commercial activities in this regard and expressing publicly an opinion with respect to the issue. Section 16 of the Act IBID provides for the establishment of Tribunals. Section 15 of the Act IBID provides, notwithstanding anything contained in any other law for the time being in force, an accused shall be tried and prosecuted for an offence in the tribunal and the case shall be heard from day to day and shall be disposed of within 90 days. The Act provides that appeal may be lodged against the judgment of the tribunal. Section 19 of the Act IBID provides, any person aggrieved by the final judgment and order of the tribunal under this Act may, within 30 days of the final judgment or order of the tribunal, prefer an appeal to the High Court having territorial jurisdiction over the tribunal. Usage of trademarks or seal etc. by other person or organization is prohibited under the Act IBID. Its Section 21 provides, no person shall use, a. any name, mark, or seal, which may resemble the name, marks, or seal of the organization or certain the expression or any abbreviation of such expression, or, b. any mark or intellectual property in relation to any article or process containing the expression Organization of Pakistan or any abbreviation of such expression. Sections 478 to 489 of Pakistan Penal Code 1860 provide for trade, property, and other marks. The sections deal with trademark, property mark, using a false trademark, using a false property mark, punishment for using a false trademark or property mark, making or possession of any instrument for counterfeiting a trademark or property mark, selling goods marked with a counterfeit trademark or property mark, making a false mark upon any receptacle containing goods, punishment for making use of any such false mark and tampering with property mark with intent to cause injury. Pakistan is signatory to World Trade Organization, WTO, thus, it is bound to follow the WTO agreement. Pakistan has also signed Berne Convention for the Protection of Literary and Artistic Works, 1886. It is signatory to the Universal Copyright Convention, 1952. Pakistan has also signed Agreement on Trade-Related Aspects of Intellectual Property Rights, 1995. The country has to follow the provisions of all such agreements. Honorable listeners, viewers, and readers are requested to refer the relevant legal documents for understanding and referring intellectual property rights. This lecture has been designed only for the purpose of creating awareness on the subject matter. It shall not be referred in any court of law or for other legal or miscellaneous purpose or claim etc.